and welcome to Crime and Court. My name is Heather, and this is a bonus episode in the deep dive that I am currently working on, which is the truth behind the Netflix hit series Making a Murderer. We are walking through all the documents, the court proceedings, the interviews, interrogations, whatever you want to call them. So we just got finished watching all 6 of Brendan Dassey's interviews with law enforcement, plus the one that he had with his attorney's investigator, who basically coerced him into a confession yet again. So we have 7 instances where Brendan was traumatized and constantly told that he was lying and not telling the truth. And so the thing is, people don't realize that false confessions can happen very easily. And we're going to watch a presentation right now. I'm really excited to bring this bonus episode to you, which is Laura Nyrider and Steve Drizek, I think is how you say his name, who are the 2 appellate attorneys for Brendan Dassey right now. And they've been trying to appeal his case. That it got denied by the Supreme Court and all that. They just didn't want to listen to it or whatever. So I don't know what other remedies they have, but at this point, I don't know where the case is with Brendan, if it's even in appeals anymore. I don't think so. Unless it was in COVID, like with everything else, COVID slowed everything down. So I don't know. I know Kathleen Zellner is still filing motions and working on Steven Avery's case. Anyway, so Brendan Dassey, a true story of a false confession, and this was 7 years ago. I do want to give credit. It is the Northwestern Pritzker School of Law, and Northwestern Illinois University is where they're at. So let's begin. I was trying to think if I had anything else to say. We're going to, like I said, this is a presentation about how false confessions can happen easily. So I just wanted to give this kind of a little bit of a palate cleanser. I don't know. They are going to go through bits and pieces of Brendan Dassey's interview as well. So they're going to break it down in a little bit. So, all right, we are at 1.25 speed, and if it's too fast for you, I feel like that's pretty good. But if it is too fast for you, you can always slow it down. It's too slow for me, so I'm compromising by doing 1.25. All right, here we go.
Good evening. My name is Steve Drizzen. I'm the Assistant Dean of the Bloom Legal Clinic. I'm co-founder of the Clinic Center on Wrongful Convictions of Youth. And tonight I'm here in a different capacity. Tonight I am here as Brendan Dassey's attorney.
Dogs want to bark.
All of you in this packed Thorne auditorium. And it's so nice to see this auditorium packed. To all of you in the 2 filled overflow rooms. To all of you in cyberspace watching us via live feed, welcome.
I did not know he's the founder. Steve Drizzen, or however he said his name, I forgot already, is the founder of the Center of Wrongful Convictions of Youth, and he's the assistant dean at the Blum Legal Clinic. That's interesting. He's also a professor at Northwestern Pritzker School of Law. I did not know they changed it to Pritzker. Pritzker's our mayor, and I don't know how governor? I don't know. Whatever. Governor. And I don't know how he got it named after him. That's interesting. He must have donated a lot of money or something. He's an interesting governor. All right. Okay.
Pritzker School of Law.
Pritzker.
Tonight, the smash Netflix series Making a Murderer comes to Northwestern as we present the case of Brendan Dassey, true story of a false confession. Tonight's program will be broken up in a number of parts. During the first part,
Hazel, stop it.
will take you inside the interrogation room. We will show you clips
Beat your
of the
butt.
interrogation, some of which were not in the movie. And you'll see
Enough.
what we saw when we first viewed Brendan's
No.
interrogation and confession, and we will explain to you why we are convinced that his confession is
Hazel, it's
coerced
okay.
and false.
You're okay. Come here.
Before we get there, let me recognize
Hazel, come
the
here.
people without which this event could not happen, without which we would not have been as successful
Knock
in
it
film.
off.
First person I want to recognize, and I'd like him to stand if it's okay, is our dean.
Abby and Hazel, enough.
Arriving in January of 2000, on the Center on Wrongful Convictions in particular, and I want to thank Dan personally for all of his support. There are two other members of the DASI legal team who are not going to be part of the formal program tonight and deserve recognition. The first person I
You,
want to recognize
especially
is
you,
Tom.
stop it.
Tom, would you stand up, please?
Dex.
Of the Bloom Legal Clinic. Tom taught me everything I know. He taught me juvenile law when I was a student here. He hired me after I graduated. He taught me how to be a clinical teacher. In the film. Tom's our most seasoned trial of this team, and we invited him, and he was the lawyer who cross-examined Mark Wiegert and Tom Fassbender, the two investigators who interrogated Brett. We have another special guest tonight, an unsung hero of the DASI legal team, who also makes an appearance in episode 10. He's Bob Dvorak. And Bob, would you stand up, please? Where are you? Bob is a criminal defense lawyer from Milwaukee. He started out as our local counsel, and pretty soon he became our co-counsel. And if we win in federal court, and I hope we do, Bob will deserve much of the credit. In episode 10, you might remember Bob's cross-examination of the smirking defense attorney Len Kaczynski and the sniveling defense investigator Michael O'Kelly. What you don't know is that Bob was like a bloodhound, and he tracked Michael O'Kelly all the way across the country. And he finally found him in Idaho. He hopped on a plane.
Yeah, go
he went
take
to
a
a
nap.
conference where
You're
O'Kelly was
good.
speaking. At the end of the conference, he served him with a subpoena. And that subpoena required Michael O'Kelly to come back to Wisconsin and bring all of his documents with him and all of his videotapes. And it was from that subpoena that we got that videotape of Michael O'Kelly interrogating Brendan on the night after his motion to suppress had been denied. So let me get a sense of who's in the audience before we move forward. How many people have watched Making a Murderer?
Okay.
I don't want hands, I want a show of claps, applause. And the reason I want applause is because I think it's really important that we honor both Maura Demos and Laura Riccardi, the filmmakers who are not with us tonight, but maybe watching somewhere, as far as I know, for their brilliant job of storytelling in that 10-episode show. I mean, they had to cut through over 1,000 hours of film footage to get to that 10-hour series, and I think they did a brilliant job. How many lawyers are in the audience? Now, be honest, lawyers. Some of you are not here for Making a Murderer purposes. You're here to get those pesky, hard-to-get CLE, professional responsibility credits. I have to remind you to turn in your CLE evaluation sheets at the beginning, at the end, and consider that reminder. If you don't turn them in, you might have to go in the marketplace and pay money to see some mind-numbing CLE programming. How many are not lawyers in the house? How many are Northwestern law students, faculty, or alumni? Is Ken Kratz in the house? If he's there, we welcome him. And this is a law school, and we welcome the free and fair exchange of ideas and points of view. And I don't know if he's in the breakout rooms or not, or if he's watching, I just want him to know that he has nothing to fear. This is a law school. This isn't a Donald Trump rally. But we hope you watch this and you will learn something, and we will make sure you get a copy. Part 2 of tonight's program will be a panel discussion moderated by Judge Michael K. Brown, a criminal court judge and former criminal defense and civil rights lawyer from Minneapolis. Okay, stand up, stand up. And joining him and Laura and I on the panel will be Bob Mylan, a former high-ranking prosecutor in the Cook County State's Attorney's Office. Bob. And Antoinette Kavanaugh, a forensic adolescent psychologist. Antoinette? Both of them will give their special insights on the interrogation and confession of Dassey. And during the session, Judge Brown will pose to us, all of us, some of the questions that you have forwarded to him. But we have a special treat for you now. Making a Murderer has struck a chord deep inside the millions of people around the world who binge-watched the film. I just learned that our dean on a Saturday started at 8 o'clock in the morning and watched it straight through with his wife. That's the way to watch it, right? But it sparked a much-needed discussion about so many issues relating.
Just on that note, I remember watching Making a Murderer myself for the first time, and I did binge watch it till like 2, 3 in the morning because I couldn't stop. I had to finish the season.
The quality of the justice we give to defendants in the criminal justice system. And one of the people who watched the film who felt compelled to act after seeing the series was a young and a talented singer, a songwriter from Hannah City, Illinois, a small town in central Illinois, not too far from Peoria. She picked up her guitar and she composed a song that so eloquently captures the pain and the loneliness and the isolation that Brendan Dassey must be feeling today. She is here tonight to perform her song with her band, The Underground.
You know, I'm going to skip because I don't want to have any like copyright strikes on me or anything, so I'm going to skip through her song. It is a very pretty song. If you guys, I recommend if you want to hear it, go here. I'll play a couple seconds at the end of it. I do have it at 1.25 speed, so let me slow it down on normal. Just a few seconds, because, yeah.
Dead man can say that he's free. Mama, they made a bad man out of me.
Alright, I'm going to stop there. I don't want to get a strike, but, it's a pretty song, and SMD and the Underground is the name. If you're looking, interested, whatever, I'm going to skip to the end because I don't want to get struck. All right, sorry.
I was asked to represent Brendan Dassey. I had a student in my class.
And if you want to listen to the or watch the performance, go to the Northwestern Pritzker School of Law, and or just search Brendan Dassey, a true story of a false confession on the on YouTube, on the YouTubes. God, I'm old. Okay, never mind.
She was one of those once in a lifetime students, and I assigned her to work on Brendan's case. Little did I know that she would grab a hold of that case and never let go. She worked on the case after she graduated. She came back to the clinic and worked on the case as a fellow for a couple of years. And I eventually hired her, and she replaced me as the legal director of the Center on Wrongful Convictions of Youth. And she has become the lead attorney in the Dassey case. It's my honor to introduce to you Laura Nyrider.
Well, I'm going to guess that the fact you're here means that most of you know the story of Making a Murderer. In 2003, Wisconsin resident Steven Avery was exonerated of a rape he didn't commit after spending 18 years in prison. 2 years after his release, he went on to be accused of the brutal murder of 26-year-old Theresa Halbach. Eventually, as the state worked hard to build a case against Avery, his nephew, 16-year-old Brendan Dassey, was swept up in the sting.
Yep.
Brendan was brought in for police questioning, initially because he was his uncle's alibi, at least in part. But he eventually gave the police a detailed confession on videotape to helping Steven rape and murder Theresa Halbach. Brendan was tried to great media fanfare as an adult. He was convicted, received a life sentence. Like his uncle, he's fighting that conviction, and we're honored to represent him in that effort. Now, the Making a Murderer story is fascinating, and it's rightly captured the attention of the nation. But while it's fascinating, and while it's a useful case to study and understand, the story is still raw for Brendan, for his mother, his family, those close to him. Because Brendan is living it. While we all sit here in this beautiful auditorium this evening, he's sitting in an 8x10 prison cell, a cage, really, in rural Wisconsin, where he's going to be sitting until he's 59 years old. This is a serious injustice for those of us who believe in Brendan. Because let me tell you right now, I believe Brendan Dassey's confession to the rape and murder of Theresa Halbach is false. And that's what I want to talk about today. False confessions. It's a hard thing to wrap your mind around. The idea that someone would confess to a crime he didn't commit. So let's begin our discussion by listening to Brendan himself explain, at least as best he could, why he falsely confessed. You all know from the series that 16-year-old Brendan was interrogated by 2 officers at the Manitowoc Police Station on March 1st, 2006, without a parent or a guardian present. The interrogation was captured on videotape, and we're going to watch several parts of that interrogation video a little bit later. But I want to start now by showing you some of the very last seconds of that tape. Because after Brendan finished confessing to rape and murder, the officers allowed his mother to come into the room and talk to him. She'd just been told that her 16-year-old son, her youngest child, her special boy with a low IQ and different needs, had just confessed to a brutal crime. And she asked him, "Did you do it?" Let's watch that moment together, caught on video, just a few seconds long.
Did you? Huh?
Not really.
What do you mean not really?
They got to my head.
Huh?
Did you catch that? Very quiet. They got to my head.
And then the officers walk right back into the room, so they don't even let the mom, Barb, get a chance to let Brendan explain where he was going. And they probably were listening and did that on purpose, in my opinion, because they don't want them to talk. They don't want them to, get someone to, tell them not to confess or whatever. They want them to stay on the side of, we need your confession. So they don't want them to change their story or anything. So they're going to act that way. So yeah, they probably came in on purpose just to stop the conversation, is my opinion.
That's it. That's Brendan's explanation for why he falsely confessed. They got to my head. Think about that. We want to spend the next hour unpacking what they got to my head means. What did these interrogators do to get to Brendan's head? What psychological pressures can cause someone like Brendan to confess or to falsely confess to a horrific crime? We'd like to answer this question by talking first about false confessions and police interrogations in general, and then dive back into Brendan's case and look at some more clips from his interrogation in depth. So let's begin by talking about false confessions. Now, the realities are that while false confessions are a very difficult thing to understand, why would someone falsely confess to a crime that they didn't commit, especially one as horrific as this crime? The reality is that the work of organizations like the Center on Wrongful Convictions and the Innocence Project have uncovered hundreds of proven false confessions. These are confessions that people have given to brutal crimes. They've been convicted, and then after their conviction, sometimes years later, DNA evidence has proven beyond a shadow of a doubt that they're innocent. In fact, in murder cases, homicide cases like Ms. Halbach's case, we know that false confessions are actually the most common cause of wrongful conviction. And here's the interesting thing. Most false confessions are detailed. They sound believable. It sounds like the person knows what they're talking about. How does that happen? We're going to talk about that tonight. But there's a couple of myths out there about false confessions that I want to dispel right away. The first one is that it's obvious when a confession is false, right? We all think, well, I'd be able to tell a false confession when I heard one because, of course, the person wouldn't be able to describe the crime. The person wouldn't sound like he or she knew what they were talking about. But that's not true. Again, these confessions are detailed. They sound accurate. They sound believable. Another myth, I would only falsely confess if somebody beat me. Right? Also not true. In these cases, there's not a single case amongst them of physical abuse. Rather, all of these false confessions that I'm talking about were obtained through the use of psychological interrogation techniques. Nobody laid a finger on these things.
Yep.
And we're going to talk about how that happened.
They got to my head. Psychological tactics, the Reed technique, to get people to confess to crimes that they didn't even commit. That's what we have all of our police officers in our country trained to do this way. I mean, for the most part, I think this is the common respected way that they all do it, and it's not right in my opinion, and it should enrage people.
Another one, only juveniles or persons with mental limitations would falsely confess. That's not true too. It's true that they're more vulnerable to those techniques in the interrogation room, but each and every one of us has our breaking point. And the question is, when do those psychological tactics in the interrogation room cross that breaking point? And in fact, we know that false confessions are so powerful, that believe it or not, 81% of people who falsely confess to crimes, who took their cases to trial, who fought their cases, who stood up for their innocence, were convicted nonetheless. This is a real problem. So we want to talk today about the 3 errors that occur during police investigation can cause false confessions to happen. The first one is the misclassification error. This answers the question, well, how did the wrong person get inside the interrogation room in the first place? Then there's the coercion error. Once you get that wrong person in the interrogation room, how were they convinced to say something so dramatically against their self-interest? And then the third error, once you've got that wrong person in the interrogation room, once you've persuaded them to make a confession, well, if you're innocent, how do you know what to say? What words are going to come out of your mouth about a crime that you weren't even there for? That's the contamination error. And we're going to talk about all 3 errors today, and then take a look at Brendan's case to show you how those errors play out in his interrogation. So let's start with misclassification. Now, to understand the misclassification error, how did that wrong person get inside the interrogation room? You have to understand how police questioning works, because there's 2 stages of police questioning. There's the interview, which is just what you would think it would be. A lot of open-ended questions, police trying to gather information. Where were you when this crime happened? Did you know the victim? Why might somebody want to do this to him or her? Information-seeking questions, just what you'd expect. And then there's a second stage, later, very different, the interrogation. Very different thing. It's not about information-seeking, because people are only interrogated. Police.
What happened?
It's a police-dominated.
It's the video.
Okay, the police dominate the interaction. It's accusatorial, and it's about getting that statement. So let's back up for a moment and focus on the interview, right? This information-seeking phase. Now, during the interview, these questions are being asked, information is being sought, but something very different is also happening during the interview. Police are trained to watch the ways in which people answer questions, to read their body language, to notice their choice of words. This is what's referred to as behavioral analysis, and that's what's really happening during the interview.
Behavioral analysis is junk science, by the way. You can say all you want, you can learn something from people's body language, which to an extent you can, but it's not like a universal, I look up left when I'm lying. That's so stupid, and it's not a universal thing. So no. Body language and that kind of thing is junk science, and there's a lot of techniques and tactics that law enforcement still do today that I would consider junk science.
Police are watching how you answer those questions, and they're making judgments based on the way in which you answer those questions, because police are actually trained that deception can be detected by the way in which you answer questions, and that all it takes is proper training for a police officer to turn into a human lie detector. So let's take a look at some of these training materials that teach this behavioral analysis. This is a handout that is used by a company called John E. Reed and Associates. They're based here out of Chicago, and about 50 or 60 years ago, they developed a psychological interrogation technique that has since become the most widely used interrogation technique in the country. About 2/3 of all officers around the country are trained how to interrogate in the Reed technique.
Okay, I was wrong. It's not all. It's 2/3.
So let's take a look at this handout, because this is a handout that Reed uses to train officers about behavioral analysis. You can see here on the left-hand side, we have deceptive denials. These are phrases that people who are supposed to be lying use. And here on the right-hand side, truthful denials. These are supposed to be indicators of innocence, of telling the truth. So let's take a look. I didn't take that money. That means you're lying. I didn't do that to her. That means you're lying. Look on the other side. I did not rob anyone. Well, that means you're telling the truth. I did not rape her. That means you're telling the truth.
Huh?
All right, let's keep going. These are some slides.
How is that scientific? How is that provable over and over and over again? It isn't. Oh my God. This makes me want to scream.
Used by the president of John E. Reed and Associates during a presentation that he gave at the University of Arkansas about his interrogation technique. And again, on the left hand, we have body language cues that are supposed to be used by somebody telling the truth. Right-hand side is cues that are supposed to be indicators of lying. So let's take a look. Truthful individuals: composed, concerned, cooperative, direct, sincere, and open. Kind of sounds like a Boy Scout. A truthful individual has open palms, maintains frontal alignment. Don't turn that body. Frontal alignment. And a truthful person makes smooth posture changes.
What?
Let's look over here, though, for lying. What means you're lying? Slouching means you're lying.
Oh, I'm screwed.
Lacking frontal alignment means you're lying. Hand over mouth or eyes means you're lying. How about this? Can you read that? I don't know means you're lying. I can't.
How many times did Brendan say in his confession, I don't know? Or not confession, but in his interrogation. How many times did he say, I don't know? That means he's lying, apparently.
Can't recall
I can't recall.
means you're lying. Referring to God or religion, my God, I would have never committed this crime.
Why?
That means you're lying.
What?
Now, if this sounds crazy to you, I think you're right. Reed and Associates claims an 85% accuracy rate for these methods of detecting deception. But virtually every independent study that's taken a look and evaluated these techniques has found that people are not human lie detectors, even officers who have been trained in this technique. Even officers who've been trained, they're no better than chance when they're trying to determine whether somebody is telling the truth or lying. They're right about 45 to 60% of the time. It's basically a coin toss. The truth is, there's no human behavior that is unique to deception. There's no physiological giveaway that will tell you when someone is telling the truth or lying.
Exactly.
This is a powerful, powerful myth amongst law enforcement because it leads to this misclassification error, making wrong assumptions about whether somebody is lying and therefore guilty based on body language and choice of words and whether they say, I don't know. This is a powerful error. It can lead to bias in the investigation, and it can trigger interrogation.
Isn't that crazy?
So the interrogator has spent some time during the interview process evaluating and assessing the body language, the verbal responses of the suspect who's in the box, and it comes to a conclusion that the suspect is lying to them and therefore guilty. And that conclusion drives the next part of the interrogation. The next error is the coercion error. So in order to understand the coercion error, you have to understand that interrogation is a guilt presumptive process. Every interrogation, and I've seen many, especially interrogators who are trained in the Reed technique, begins the same way. There's usually a break.
Oh my God.
And the interrogator will come in after the interview process.
I'm sorry. The face I just made. Okay, so I've got in the background, I've got the Blackhawks game on, and it's still the first period, and it's the score's 4-0. Blackhawks are losing. That just like I didn't see the goals, but I just looked up and I'm like, whoa, how did we get to 0-4 or 4-0 already? So never mind. Sorry, we're losing.
Process, and you will make a direct accusation to the suspect that the suspect is guilty. We're not here today, Brendan, to talk about whether you committed this crime. We already know you committed this crime. We have the evidence, and oftentimes they'll have a file filled with papers in it. It'll be blank papers that they use as a prop. I've been investigating this case for weeks now.
Blank papers they use as a prop. They all come in with a folder or some kind of notebook or something. And the one guy had like the notepad so that he could draw all the pictures. But yeah, isn't that something? They'll come in with a blank stack of papers just to mess with your head. Because that's what they're doing. They are trying to mess with your head. That is what these techniques are for.
I've talked to
It's
many
ridiculous.
people, and everybody, every piece of evidence I've come up with points that you're guilty. What we need to find out today is why you committed this crime. At the beginning of an interrogation, an innocent person's confidence that they will emerge from the interrogation process unarmed is sky high. What do they have to worry about? They're innocent. Oftentimes they're here to cooperate. Many times they just volunteer to come to the police station because they have nothing to worry about. But the goal of interrogation is to bring back.
How about Richard Allen, who volunteered to go to the police station to give information about the Delphi case, and now he's a suspect, and he's been sitting in prison for over 2 years? Or no, over a year and some change now, I think. Anyways.
That confidence level down to such a low point, to such a place of hopelessness, where the suspect no longer believes that his innocence can save him, and where he is powerless to resist the accusations and the demands to confess. When the suspect...
Basically, what he just said is they break you down. All your confidence, all your self-esteem, all of that, I mean, all your confidence in like, I'm going to get out of this unscathed because I'm innocent. All that goes out the window. They break you down piece by piece. They try to get more out of you. If anybody is ever, I mean, I'm not saying do crimes or anything, but I'm saying if you are in a situation where law enforcement wants to question you about something, I would just say think first before you go without a lawyer. That's all I'm saying.
reaches that low point, the Reed technique is designed to give the suspect an out. And we'll talk about that in a second. So here's Robert Taylor. He's one of the clients we exonerated here at the Center on Wrongful Convictions. And this is how he described this overwhelming process of interrogation. Being interrogated felt like I was choking, like there was no more air left in the room. After the confrontation phase, the next thing interrogators are taught is to interrupt the suspect. Don't let him say that he or she is innocent. Don't let them assert their innocence, because Reed teaches as interrogators that the more the suspect asserts their innocence, the more they become psychologically attached to the notion of their innocence, and the harder it is to get them to confess. You'll see at this stage that interrogators will move very close to suspects, knee to knee, within touching distance of the suspect. And many times they will touch or pat the suspect to urge them on to confess.
I would hate that.
And during this process, what we see in almost every case of a false confession are what are called false evidence ploys. And false evidence ploys are lies about evidence, claims that police officers have evidence against the suspect that they really don't have. And this can send a suspect into a place of panic and desperation. Once that suspect is in that place, and remember, these false evidence ploys, they can be both general or specific. Usually they're more general, because if a police officer tells a suspect, we have your fingerprints, we have your DNA, we have you on video, the innocent suspect will know that that's not the case, or at least there's a risk that he will know that that's not the case and not believe police officers. Usually they're more genuine. It's the omniscience ploy. The all-knowing police officer telling the suspect over and over again, we already know.
And that is exactly what they did to Brendan. They kept saying, we already know what you did. We already know what happened. Just tell us the truth. Just keep telling us. Just tell us the truth. They kept saying that over and over again. And then anytime he did say something, they're like, I don't think that's the truth. I think you're lying. It's like, come on now. Anytime he talks, it was wrong. But whatever.
And police officers are allowed to lie, and they have lied with abandon since 1969 in the Supreme Court decision of Frazier versus Cupp that blessed the practice of using deception with during interrogation.
And why is it still, 69? Come on, guys. It's 2023. Let's change the law. Come on. Not all laws have to be set in stone. Just saying.
Now, it's important that although police officers are allowed to not lie, John E. Reed and Associates cautions police officers not to lie under these circumstances. Deceptive tactics should not ordinarily be used with individuals who have significant mental limitations, or with young children, or with youthful suspects of low social maturity. In the next edition of Reed's manuals, he should have a picture of Brendan Dassey next to those words.
Yeah.
After the suspect is at that low point, we see the tactic of minimization. This is the out. The out is a suggestion to the suspect that there are only two alternatives, both of which make the suspect guilty, but one of which gives the suspect a face-saving moral or legal excuse, while the other paints the suspect as a cold-blooded, heartless, deliberate, premeditated killer. Did you intend to kill the victim, or was it just an accident? Did you plan this act, or was it just a temporary loss of self-control? Did you instigate the assault, or were you just responding in self-defense? Did you want to participate in the rape, or did your uncle force you to do it? These alternative questions that give suspects two choices are implied promises of leniency. The suggestion is that,
And they did this to Brendan countless times, where they only gave him one or the other option. And it felt like they put you in a box. You have this option or this option. You have to pick one. So every time it seemed like Brendan was so hesitant to choose one because neither option was good. But ultimately, he would surrender to whatever the cops were telling him to do.
you accept the less heinous version, that you will be treated more lenient in the criminal justice system, and they work. Unfortunately, they also work to produce false confessions. These are three other teenagers who falsely confessed the crimes they didn't commit, and the perception they got from signing this confession or from agreeing to the police story was that if they just confessed, that they would be allowed to go home. The police officers didn't say specifically, you'll be able to go home, although they did say things like, we'll wrap this up soon, you can get on with your life, other kinds of phrasings that suggest that they could go home. Once the suspect...
And if you have deficiencies in your cognitive abilities, you would not necessarily think, especially like social skills too, you wouldn't necessarily think that you would be going to prison. I mean, especially when you're being baited to say all the details and all the things. Hold on. I don't know why my dogs want to bark. Sorry. Yeah, especially when they're being baited with all this false information. Or with all the information, all the case details. That's how they're coming up with their narrative. Anyways.
Admits to some involvement in the crime, the police officer's job is not over. Because while getting an admission is powerful evidence, what they need to get a conviction is to have the suspect give the police officer the details of the crime that only the true perpetrator would know. Now, this is a real problem for an innocent person. He's got to guess to come up with those details. As Laura said at the beginning of this presentation, many of these confessions are filled with details, and many of those details are accurate. How does that happen? Well, it happens through the third error, which is the contamination. And the most significant source of contamination is what's called fact feeding, leading questions by the interrogators that give the suspect the answers that they are looking for, and the suspect will adopt those answers and incorporate.
Yeah, like, who stabbed her in the head, Brandon? Or who stabbed her, Brandon? Who stabbed her? Who shot her in the head, Brendan? Like, the police don't even know that she was shot or stabbed. All we know is that she was burnt. And probably put in the back of her or her RAV4. And I doubt that would have been... Why would Steven Avery knock her out and put her in her... I don't know. Doesn't make sense.
Break them into his own confession. Sometimes it's leading questions. Sometimes they show the suspect crime scene photos. Sometimes they take the suspects, as they did in the Central Park jogger case, to the actual crime scene. All of this kind of police fact-feeding is frowned upon by everybody in the world of policing. Here's Neil Nelson. He was a police commander in St. Paul. He took a false confession from a 13-year-old to the murder of his father. And it was only after he reviewed the recorded interrogation that he realized that he gave all of the details to the suspect. And thank God it was videotaped, because that videotape allowed him to see where he went wrong, and he forced the prosecutor to drop the charges.
Wow. That, like, never happens.
Right, so we talked about the three errors, right? Misclassification, coercion, contamination. And now we want to turn to Brendan's case and take a look and see if we can find those errors in the police interrogation that he endured, okay? So to start out, let me give you a little bit of background. Brendan, as we saw in Making a Murderer, was questioned at the police station on March 1st, 2006, which is where he confessed to the rape and murder of Theresa Halbach. But what Making a Murderer did not show was that that was the fourth time over a 48-hour period that Brendan was questioned by police, okay? Now, the first time is this up here.
In a 48-hour period.
The early afternoon of February 27th, 2006, officers come to Brendan's high school. He's in 10th grade, 16 years old. They have him pulled out of class. They bring him up to the principal's office, and they question him there. Now, this interrogation is only captured on audio tape. They didn't bring a video camera with them, so that's all we have. And it's really hard to understand audio tape, so I'm going to play a little bit of it for you here in a minute, and you'll see what I mean. But that's only the first thing that happens. While they're at that high school, those interrogators ask Brendan about the fact that he was at his uncle's house for about an hour that night. He did help his uncle build a bonfire. They did that all the time, right? Nothing unusual for Brendan. But over the course of that audio-taped interrogation, they say things to Brendan like, "You must have seen things in that fire, Brendan. Come on, Brendan. What did you see? You must have seen a hand, Brendan. You must have seen feet, Brendan. A head. Something." And over the course of that interrogation, Brendan eventually agrees. He says, "Yes, I saw fingers, toes, and a forehead," parroting back exactly the same body parts that the officers told him they knew he had seen. They also plant with him the idea that there was a sexual assault involved. Well, Brendan, after you saw the fingers and the toes and the forehead in the fire, you must have talked to your uncle about it and asked him, "What is this?" And he must have told you that he assaulted this young woman. Isn't that right, Brendan? And eventually, on audio tape, Brendan says, "Yes, that's what my uncle told me." So after getting the statement from him at the high school, they take him then that same afternoon to the Two Rivers Police Department, the nearby police department. And there they put him on video. That's a screenshot of the video. And there they get him to repeat the statement that they worked on at the high school. So now they capture it on videotape.
We listened to both of those on my channel here.
Later on that evening, there's a third questioning session that same day. It's at a local hotel. It's in the late evening. Now, I don't know much about it because that entire questioning session was unrecorded. We don't know exactly what was said. We don't know exactly how long it lasted. But we do know that 2 days later, on March 1st, 2006, the officers came back to Brendan's high school. They pulled him out of class again. They put him in the backseat of their police car, and they drove him 45 minutes away to the Manitowoc County Police Department. That's where the interrogation that we saw in Making a Murderer happens. And that's where Brendan gives his confession to rape and murder. So let's take a look. Let's think about that first error we talked about, the misclassification error, right? This behavioral analysis idea. Remember this slide. This is the slide of characteristics that are supposed to be shown by people who are lying. So let's look. It says slouched. Here's a screenshot of Brendan's interrogation. He's slouched. It says hand over mouth or eyes. Sure enough, he's got his hand over his mouth. rigid and immobile. Well, this is a screenshot, but what you're going to see in the videos is he doesn't move very much. He kind of stays in that one position. Barriered posture. He's got his hand in front of him like this. It's a barrier. And, as for these verbal things, somebody who says, I don't know, must be lying. Let me tell you, if there's one thing that Brendan Dassey said hundreds of times during that interrogation, it's, I don't know. I think what was happening in that interrogation room is the officers were using this notion of behavioral analysis to make judgments about Brendan based on his body language, based on his choice of words, based on the fact that he answered questions, I don't know. And we can see where that got us. Now there's another part to this misclassification error, I think, in Brendan's case. Okay? This down here is an email that was sent by a man named Pete Bates. He was the defense investigator hired by Dean Strang and Jerry Buting, Steven Avery's attorneys. And the defense investigator was researching Brendan's background just in case Brendan decided to testify against his uncle. They wanted to be prepared. So this is an email that investigator sent to Dean and Jerry. Let me read it. He says, this kid, Brendan, has had problems since kindergarten, particularly in the social area. It's noted from as early as 3rd grade that he can't look an adult in the eye. He's withdrawn. He doesn't function well with others. He's been in special ed classes since grade school. He has trouble understanding vocabulary both to and from him. He's been continually diagnosed as having a learning disability. He's easily intimidated and withdraws into himself in confrontational situations. This is Brendan's disability. But I think that too, these characteristics too, caused those investigators to make the wrong judgments about Brendan. This failure to look people in the eye, this withdrawing during social situations. This is his disability, and I think it also is the misclassification error. What I'd like to show you now is a couple of clips from Brendan's interrogation. I'm going to start here with clips that show the coercion, the second error that we talked about today. In particular, clips that show that omniscience ploy that Steve talked about. This tactic of pretending that the interrogator knows everything there is to know about what happened. There's nothing you can do to fool me. I know it all already. Let's watch this unfold. And these clips that I'm about to show, just to orient you, are from the interrogation on March 1st, where they begin talking about things that Brendan had previously said 2 days earlier on February 27th.
And we know, like Tom said, we reviewed those tapes. We know there's some things you left out. And we know there's some things that maybe weren't quite correct that you told us, okay? We've been investigating this a long time. We pretty much know everything. That's why we're talking to you again today. Why did he have you come over there? Did he need help with something? Remember, we already know. We need to hear it from you. Why did he have you come over there? Brenda, were you there when this happened?
No.
Was she dead there then or not?
Yeah.
How do you know that? I have a feeling I know how you know that. We already know, Brandon. We already know. Come on, be honest with us. Be honest with us. We already know. It's okay. We're going to help you through this, all right? Oh, come on, be honest. You went back into that room.
Don't let us down, Brendan.
We know you were back there. Let's get it all out today. This will be all over with. Brendan, be honest. You were there when she died. We know that. Don't start lying now. We know you were there. What happened?
Let's just start with the room in which he finds himself. You notice Brendan is sitting on a couch, but he's literally backed into a corner, isn't he? And he's got 2 police interrogators right in front of him, blocking the exit to the door, which is to his right. And what are they saying to him? We already know, Brendan. They're building a psychological wall. We know what's right. You can't dissuade us. There's nothing you can say to shake our belief that we know exactly what you did. And they walk him through every fact of the case. It's just a sample. You were there, Brendan. We already know. You went back in that room, Brendan. We already know. You were there when she died, Brendan. We already know. Again and again and again. And I think that this dynamic, frankly, was particularly devastating for somebody like Brendan, who's just a kid in school who always gets the answer wrong, but really wants to get it right. So this is part of the presentation of false evidence against Brendan, the officers claiming that they know exactly what happened. Part of that process of confrontation and accusation. And it goes on for some time. But after this process brings Brendan down to that point of hopelessness, my God, they say they already know what I did. They're telling me they have evidence. They're not letting me even assert my own innocence. They just keep accusing me. What am I going to do? What am I going to do? After they bring him down to that point of hopelessness, these officers tell Brendan what's at stake. They remind him what's at stake. And then they offer him that out that Steve talked about. So this theme, these next clips that I want to show you, they start on February 27th, so you'll hear that audio from the high school. And then it continues on March 1st. Let's watch.
You've got people back at Sheriff's Department, District Attorney's Office, and everything else, and there's no way they're going to get out there and they see something. They're talking about trying to get them from the gas with this event. Not saying that Brendan did it, saying that Brendan had something to do with it or cover it up all of it, which would be from the gas and potentially be facing charges for that. We've got a lot of information. You know, some people don't care. Some people back there are saying, well, it's charging. So no, what is talking about? You know, obviously you have forward this information and you have your opportunity chance. You know, make it look, you can make it look how you want.
We want to go back and tell people that, you know, Brendan told us what he did. We want to be able to tell people that Brendan was honest. It's not like Steve. He's honest. He's a good guy. He's going to go fights in this life. But in order for us to do that, you need to be honest with us, and so far you're not being 100% honest.
Are going to go on over that? That's very straightforward. We'll understand that.
We'll go back for you. Yeah, be honest with you.
Because Mark and I looked at the tapes, looked at the notes, and it's real obvious there's some places where some things were left out or maybe changed just a bit to maybe looking at yourself to protect yourself a little. From what I'm seeing, even if I fill those in, I'm thinking you're all right. Okay, you don't have to worry about things. We're there for you, and we know what Steven did, and we know kind of what happened to you when he did. We just need to hear the whole story from you. And as soon as we get that, we're comfortable with that. I think you're going to be a lot more comfortable with that. It's going to be a lot easier on you down the road if this goes to trial and stuff like that.
Honesty here, Brendan, is the thing that's going to help you. Okay, no matter what you did, we can work through that. Okay, we can't make any promises, but we'll stand behind you no matter what you did. Okay, because you're being the good guy here. You're the one that's saying, you know what, maybe I made some mistakes, but here's what I did. The other guy involved in this doesn't want to help himself. All he wants to do is blame everybody else. Okay, and by you talking with us, it's helping you. Okay, because the honest person is the one that's going to get a better deal out of everything. You know how that works. You know, honesty is the only thing that'll set you free.
So this is getting serious for Brendan now, right? They've already told him, we know everything there is to know about this case, we know exactly what you did. And the district attorney now, they tell Brendan, the district attorney is thinking about charging you in a murder case. But you know what, Brendan? We can help you. We can go to bat for you. But you have to tell us what we believe is true. Honesty, Brendan, is what will set you free. That's what they tell him. And they promise him all of these things are promises of help if he just says what the interrogators believe to be true. They even say to him multiple times, I'm going to help you out, Brendan. Now, these promises of help, interestingly, in recent years, just the past few years, have been disavowed by Johnny Reed and Associates, that company that trains police officers how to do interrogations. It says avoid interrogations that are centered on this theme that the person will get help if only they confess. But that came too late for Brendan, because this is just a sampling. Over those 4 interrogations, over and over and over, we hear, Brendan, I'll go to bat for you. Brendan, I'll help you. You'll be set free, Brendan. You just need to be honest with us. Now, these promises, I believe, were particularly potent in Brendan's case because of some other things that the officers said. I'm going to show you a few more clips, both from the high school and then from March 1st at the police station, in which the officers told Brendan that they weren't officers, after all. Let's watch these clips.
Yeah. Not like
Wow.
She's my full right. You're helping.
Your mom said you'd be honest with us.
She's behind you 100% no matter what happens here.
That's what she said. Because she thinks you don't want to do it.
We're in your corner.
We already know what happened. Now tell us exactly. Don't lie.
Well, that's powerful. On a 16-year-old, your mom thinks you know more than what you're telling us? Your mom told us that you'd be honest and tell us those things? Well, of course, that's a lie. She never said that. But Brendan doesn't know that. And they're telling him, your mom wants us to say these things that we know are true. And they ally themselves with Brendan's parents. We're cops, but we're not right now. I'm a father. I've got a son your age. I want to come over there. I want to give you a hug. No wonder these promises of help hit home for Brendan. These officers who are saying these things to him are acting as though they are going to protect him, like a parent would protect a child.
There were three facts, three absolutely critical facts in this case that were not widely known in the media, in the general public. Johnny Reed and Associates tells investigators that they should hold back some facts, because if the suspect can give you those facts, then you have a pretty good idea that what the suspect is telling you is true. Even better, if the suspect can lead you to evidence that the police didn't even know about, that's a pretty good indication that the suspect, in fact, committed the crime. But there were three held back facts. And the investigators in these next clips are desperate to get Brendan to give them these facts. What happened between February 27th and March 1st? There was no interrogation on February 28th. One thing that happened was that the investigators got a report from the Wisconsin State Crime Lab. And for the very first time, they learned that Theresa Halbach had been shot and that she had been shot in the head. They needed Brendan to give those facts to them. They also knew another fact. They knew that somebody had disconnected the battery cables from the battery in Theresa Halbach's car. They needed Brendan to say that either he did that or his uncle did that. And they also knew the whereabouts of Theresa's purse, her camera, and her cell phone. They were found in a burn barrel on the salvage yard. If Brendan could give them those details, they could be assured that Brendan had committed this crime. Now let's see how they got those facts.
Where did he stab her?
In the stomach.
What else did he do to her? Did something else, we know that. What else?
He tied her up.
We know he did something else to her. What else did he do to her?
He choked her.
What else did he do to her? We know something else was done. Tell us. Or what else did you do? Come on. Something with the head. Brendan?
Yeah.
What else did you guys do? Come on.
What he made you do, Brendan, we know he made you do something else.
What was it? What was it?
We have the evidence, Brendan. We just need you to be honest with us.
That he cut off her hair.
Okay, what else?
What else was done to her head?
That he punched her.
What else?
He clearly does not know what the cops want him to say, so he is just grasping at things, and he's taking guesses, shots in the dark, to try to see what sticks, and the cops are going to feed it to him in a second here.
What else?
He made you do something to her, didn't he? So he would feel better about not being the only person, right? Yeah. What do you make you do to her?
What do you make you do, Brendan? It's okay. What do you make you do?
Caught her
Cut her where?
on the throat.
What else happens to her in her head?
Extremely, extremely important to tell us this. For us to believe you.
Come on, Brendan. What else?
We know, we just need you to tell us.
That's all I can remember.
All right, I'm just gonna come out and ask you. Who shot her in the head?
He did.
Why didn't you tell us that?
So I couldn't think of it.
Okay, what else did he do?
Because he couldn't think of it, because it didn't happen. He couldn't think of it because it didn't happen, and you just fed him the key piece of evidence that you needed. And I do want to say, like, how did they even know that she was shot? Because there were just bone fragments. So I don't know if they found a part of her skull that looked like it had been shot. So I don't know. But for the most part, it was bone fragments. And there was something in Making a Murderer, too, that they were saying that, like, the ribs are really hard to burn completely. There would be a lot of fragments of those, and there weren't. So it almost seems like there were potentially pieces of her that might have been moved or buried or something. I don't know. But something other than being left there with all the rest of the items that were burned, including Theresa and her belongings.
If you did something else, you need to tell us what you did. After that car was parked there. It's extremely important. Before you guys leave that car.
They left the gun in the car.
That's not what I'm thinking about. You did something to that car. Took the plates, and I believe you did something else to that car.
Oh.
Okay. Did he go and look at the engine? Did he raise the hood a little or anything like that? To do something to that car?
Yeah.
What was that?
What did he do, Brendan? It's okay. What did he do?
What did he do under the hood if that's what he did?
I don't know what he did, but I know he went under.
Did you put some things in that burn barrel that night?
No.
What happened to Theresa's other personal effects? I mean, a woman usually has a purse, right? Tell us what happened to that.
I don't know what happened to it.
What happened to her cell phone? Just,
I don't know.
Did you see whether a cell phone of hers?
No.
Do you know whether she had a camera?
No.
If you know what happened to a cell phone or a camera or her purse, you need to tell us, okay? It's over. Do you know what happened to those items?
He burnt them.
How do you know?
Down.
Because when I passed it, there was like a person there and stuff.
When you passed what?
The brain veil.
Did you look? What did you see?
Like a cell phone, camera, purse.
All of the items that they fed to him. They just literally fed those items to him, and then he repeated them right back to him, right back to the investigators.
It is extremely important, Brendan, that you tell us this information. That's Tom Fassbender telling that to Brendan. You need to tell us this information so we can believe you, Brendan. That's Mark Wiegert telling Brendan that. They knew they needed this information. They wanted this information. And they wanted it in the worst way. And they got it in the worst way. They fed Brendan those key facts. And then they suggested to a jury that Brendan had come up with them on his own. He didn't. This is one of the worst cases of police contamination I have seen in over 20 years of looking at interrogations. It is terrible police practice, and it led, in part, to Brendan's wrongful conviction.
Yep.
So what happens now? Brendan has confessed. He's given them the details that they had fed to him. They've got what they think they need. They have that narrative, a horrific narrative, a narrative that has caused people in Wisconsin to have nightmares. We've heard from some of them. It's a narrative that we believe is completely false. And the reason we think it's false is because there's not a shred of any evidence in that trailer to suggest that Brendan was ever there. There's no blood, there's no semen, there's no saliva,
there's no evidence that Theresa was even there, for that matter.
fingerprints linking Brendan to that trailer. There's no marks on the headboards from the handcuffs that were supposedly used to restrain her. And I ask you, I've had 3 16-year-old boys. I know 16-year-old boys. They can't make a peanut butter sandwich without leaving a mess. Do you really think Brendan Dassey is going to be able to clean up that mess so well that he leaves no trace of himself in that room? It didn't happen. They tore apart those floorboards. They tore apart the paneling on the wall. They dug deep into any cracks in the foundation. There was no trace of her there. So what happens after Brendan confesses? And these clips, these are 2 of them before the mother is brought in, before Barb is brought in, and 2 after. The police leave the room, and Barb enters the room. And to me, these are the most heartbreaking clips in the entire interrogation. And let's watch them very quickly.
Am I gonna be at school before school ends?
Probably not. I mean, we're at 2:30 already. And school's over at what, 3?
3:05.
3:05, yeah. No.
What time will this be done?
Well, we're pretty much done. You know, we have a couple of follow-up things to ask you, but it's pretty much done. You do understand that you're under arrest now?
So could I call my girlfriend and tell her that I can come today?
We'll give you an opportunity to do that. Okay?
Aww.
I mean, honestly, after telling us what you told us, you kind of figured this was coming. Yeah?
This is only for 1 day. Where am I going?
Where do you think you're going?
Oh.
You're going to juvie. That's where you're going. To juvie jail. About 45 minutes away.
Yeah, but I have a question.
What's that?
What happens if he says like his story is different, but he says he admits to doing it?
What do you mean?
Like, if his story's like different, like I never did nothing or something.
Did you? Huh?
Not really.
What do you mean, not really?
They got to my head.
Huh?
I'm saying it to you.
And just like that, they walk back in right after he says they got to my head. And Mom goes, "What?" and tries to figure out what the hell. Okay, my laptop is being weird. And Mom tries to figure out what the hell is happening with her son and why he's confessing to something he didn't do. And if these people got into his head.
What do you mean by that? you mean by that, Brendan? Were you pressuring him?
Who are you talking about?
Him.
What do you mean pressuring him?
I'm talking to him.
No one told me he needed to know the truth. We've been doing this job a long time, Barb, and we can tell when people are telling the truth.
Really?
And in my opinion, he'd never be able to live with it himself if he didn't tell somebody.
Testing? Okay, sorry. Cops that think that they know better than everybody else and they know they're above the law and they're like, yeah, we can tell when someone's lying. We've been doing this job a long time. Get the hell out of here. You have no idea if someone's lying to you or not. These techniques are bogus. They're psychologically traumatizing to people. And that's how you're getting confessions. But yet, like, because I saw a recent something or other I watched, and it was like recent clips, I think, of a Dateline or whatever, of an update of Making a Murderer. It was like an older thing, but I just watched it recently. And Fassbender, and I don't know if Uyghur was on, but I know Fassbender was on this interview, and he was like, oh yeah, we stand behind our confession, and I thought it was real, and all this. So yeah, get out of here with that. I don't believe you.
No way he could live with that. Nobody could live with that. And I think Brendan knows that.
It's so heartbreaking because here's a child
Do you need to go out
who doesn't
again?
know where he's going. He doesn't know for how long he's going. Only for a day? Here's a child who just confessed to participating in a rape and murder, and he thinks he's going back to school.
Yep.
Where he wants to go. There's a project period he has to complete. We also have come full circle.
Oh, whoops, here.
The officer comes in the room and he says he can tell when people are telling the truth because he's been doing this for a long time. And the result of such thinking in this case is what Laura and I believe is a false confession. It got to my head. This is Brendan's way of recanting. And note that he recants at the very first opportunity when he and his mother are alone. And note how he shuts up immediately when those interrogators rush back in as his mom starts trying to get at why he confessed, and he says they got to my head. The best interpreter of what Brendan meant by they got to my head, the only real interpreter was Brendan's mother. She knows what it means when he said that. She knows that it means he was pressured into lying. These last clips, especially the one with Barb and with Brendan, were never shown to the jury in this case. They never got an explanation from Brendan as to why he confessed in that moment, right after the police officers were finished. Where are we today? We've just taken you through the 3 errors that we see in all false confessions, and we've taken you through the clips that we believe show they were present and they controlled the outcome in Brendan's case. The court declined to suppress Brendan's confession. The motion was brought by Len Kaczynski, his attorney. We don't believe it was litigated very aggressively by Mr. Kaczynski, but again, during that motion to suppress, the tape was never played for the judge. He was convicted on the basis of his videotaped confession. The recantation was never shown to the jury. There was no expert testimony presented in this case to describe the phenomenon of false confessions. No experts were presented, even though Dean Strang and Jerry Buting had hired an expert to evaluate Brendan's confession, and that expert was ready to testify in the event Brendan flipped and testified against Steven at his trial. That expert was ready to testify in Brendan's case, but his lawyers chose not to call him. The other thing the lawyers did in their defense case, and they were much better lawyers than Len Kaczynski was, but they didn't know how to litigate a false confession case. They never once played the tape in their case in chief. So the only time the jury saw this confession was when it was played straight through in 3.5 hours from start to finish, and they never played that recantation. Unless you break it down into chunks for the jury, unless you show them what we showed you today, that all gets lost in the mind and the eyes of a jury. You need to use the tape. We litigated this case all the way through the state courts. We spent a week in Manitowoc, Wisconsin, put on all this evidence. our post-conviction petition was denied. We took that up to the appellate court. We lost again. We tried to get this case to the federal court, into the state Supreme Court. And they denied our petition for leave to appeal. So now we're in the federal court.
Come here.
We have two claims that we're raising in habeas corpus.
Okay,
One
I don't
relates
know.
to ineffective assistance of counsel, for Len Kaczynski's decision to leave and abandon Brendan with the police officers to get another confession from Brendan, and a phone call from that confession session from Brendan to Barb was used against Brendan at trial. And we're litigating the voluntariness of the confession, making the case that Len Kaczynski should have made, that this was both a coerced and contaminated confession. We're going to now move on to the second part of this, and I'll turn it back to Laura.
Well, it's now my pleasure to introduce to you the Honorable Judge Michael Brown, who will be moderating tonight's panel discussion. The Honorable Judge Brown was appointed to Minnesota's 4th Judicial District Court by Governor Mark Dayton on September 4th, 2015. He's currently assigned to the Civil and Criminal Rotation
up here.
and serves on the statewide Judicial Technology Committee. Prior to joining the bench, Judge Brown was a civil rights attorney and served in numerous appointed positions with the Minneapolis Department of Civil
Abby,
Rights
come here.
and the Minnesota Human
come up
Rights
here.
Department. He also practiced criminal law and authored academic articles on police practices. Judge Brown has been an adjunct professor and a faculty mentor at the University of St. Thomas School of Law in Minneapolis for 8 years, where he recently moderated a Making a Murderer panel there as well. Please welcome me and please join me in welcoming Judge Brown.
He's tall. It's a tall guy. It's going to go into a panel presentation, which I'll keep it rolling because I think it might be, if you guys find it interesting, feel free to stick with me.
I want to start off first by highlighting some things that I've learned about the Center for Wrongful Conviction of Youth. And I think this CLE is really well in line with the mission that the center has, which is to do outreach, advocacy, education, and litigation that seeks to implement policies and practices that will ensure that the evidence used against youth is reliable. Now, since the debut of the Netflix show this last December, many viewers of that documentary have become interested, frustrated, and sometimes confused about the systemic problems in the criminal justice system as highlighted by Brendan Dassey's case. Now, because entertainment and media have pushed these issues into the mainstream conversation, it's critical that we address them now, and that is well in line with this panel. And let me just start out by saying and sharing a story, if I can. One of the typical questions that I may ask potential jurors is whether or not they watch any crime drama television shows. That's awfully helpful question to ask, because then you get a sense of what people think is going to happen in the trial. And prior to December, I had what would be, I think, typical or standard answers, standard television shows, CSI, and the like. But after December, I asked the question in a very serious felony case, and I actually didn't get a whole lot of hands up. Out of a group of 25, I thought that was kind of surprising. And then one brave soul raised her hand, and she said, well, does making a murderer count? I thought, yes, it does. That's what I'm asking. I said, okay, hold on. Raise your hand if you've seen Making a Murderer. And my goodness, everybody's hand went up. I actually had to ask the question in the reverse. I said, okay, put your hands down. Okay, raise your hand if you haven't seen it. And there was like 2 people. I called them and they said, well, we're going to go and watch it. All right, but my point is that this is the sort of effect that's having on the legal profession. And so this conversation, I think, is very appropriate. So the purpose of the panel this evening is to discuss the juvenile justice issues that are being raised by the documentary, specifically The panel is going to talk about false confessions, police interrogations, and wrongful convictions. So, you have now heard from clinical professors Laura Nyrider and Steven Drizin, the attorneys for Brendan Dassey. And we also have some takeaway points. The 3 errors in the interrogations is going to be one of my takeaway points. But our panelists tonight are going to be joined by 2 other experts, Dr. Antoinette Kavanaugh and Mr. Robert Milan. Now, I'd like to begin with Dr. Kavanaugh, who has earned her PhD in clinical psychology from Northwestern University's Freiburg School of Medicine and her board certification in forensic psychology through the American Board of Professional Psychology. Now, she has served as the clinical director of the Juvenile Justice Division of the Cook County Juvenile Court Clinic and was the clinical professor at Northwestern University School of Law for 10 years. And in her private practice has been retained as an expert on multiple Miller versus Alabama cases and evaluates youth and adult in a variety of forensic issues. Now, Mr. Milan is the managing director at Strotz Friedberg firm in Chicago office, and I understand that office has locations across the globe. He provides strategic consulting in a variety of matters that deal specifically with digital technology. He's kind of a digital detective, if you will. Before joining that firm, he was an assistant United States attorney in the Northern District of Illinois, where he's prosecuted cases on all levels. He's also served as an adjunct professor at the Chicago Kent College of Law and has been a guest lecturer at various distinguished law schools around the country. So I'd like to...
As a former DA, I wonder what his perspective is going to be on false confessions from kids. Let's find out. It's interesting.
Join me in welcoming our panel for discussion tonight. All right, so you heard a little bit about my background, and I am on the Minnesota statewide Judicial Technology Committee, so I'm going to try to use the technology. That's always been part of my plan. I'm in between. I use technology and I use paper. We'll use them both tonight. So here's what I want you to do. I want you to join me with the technology. The audience will have an opportunity to ask questions, and we had originally reached out to those who RSVP'd and asked you to send in your questions. I actually have some of the questions that you've already sent in. Now, if during this conversation or anything that you've heard tonight, you'd like to ask a question, we'd like you to send that email to that address that you see there. What's going to happen is that I'm going to get that, and I'm going to vet those questions, and we'll try to integrate those questions into the conversation we're going to have tonight. Just a couple of things I want to point out about it. First of all, the panel tonight is going to be focusing on aspects related to Brendan Dassey's case. So the panel will not be taking any questions about Steve Avery's case. Also, I'm not going to talk about the theories of that case or get into the weeds on any evidence issues specifically. All right, so with that, what I'd like to do is I would like to jump in right away to questioning. And for the first round, I think what I'd like to do is I'd like to start with Professor Nyrider. And you just gave a very interesting conversation and presentation on the subject of juvenile false confessions. And so what I'd like to know from you is this: what is next? What can be done to prevent juvenile false confession?
Well, it's a great question, and it's something that a lot of people are thinking about, especially in the wake of making a murderer, right? What do we need to do to prevent situations like this from happening again? There's a wonderful organization out there in law enforcement called the International Association of Chiefs of Police. This is an organization that we've worked with to write the first ever juvenile interrogations protocol that is geared at avoiding false confessions from people like Brendan. And this is a fantastic protocol because it makes a lot of specific recommendations that you can match up to exactly what went wrong with Brendan, right? It says never make these sorts of promises of help that we saw during Brendan's interrogation, right? Never suggest to a child that they're going to get to go home, back to school, whatever, if only they tell the truth. It says never disclose facts about the crime during an interrogation. Don't be feeding the information to the person you're trying to get the confession from, because then it's not really their confession, it's your confession, right? You're just putting it into their mouth. And it makes other very important recommendations. Don't let a child like Brendan go into that interrogation room without a parent, or better yet, without a lawyer who can adequately make sure that kid knows what's at stake, so that child doesn't sit there thinking, this is only going to be for one day, or I get to go back to 6th hour after this happens.
or go hang out with my girlfriend after school. And did you see him say, I gotta call my girlfriend because I'm not gonna be there? It's so sad. He had plans with his girlfriend after school that day. Makes me so angry.
Mr. Malley, from the prosecutor's perspective, does the lack of corroboration in Brendan's confession in the form of evidence or otherwise give you pause or concern?
Yeah, from a prosecutor's perspective, Dr. Kavanaugh and Laura and others can talk about, the child's psychological issues and the demeanor, as Laura pointed out, and those things that others look at. But from a prosecutor, the way I looked at the case was corroboration. And to me, and I've taught this over and over again, but a confession is absolutely worthless unless you can corroborate. I'll say it again. A confession is absolutely worthless unless it can be corroborated. And if you look at the Brendan Dassey case, there is zero corroboration to back up that very, very weak confession he gave. The evidence that would have been left at that scene could not have been cleaned up by the sharpest individual, let alone Avery and Dassey. There is no way they could have cleaned up all that blood. There is no way that there wouldn't have been marks left from shackles on the bed and everything else. There's no way that young woman's hair wouldn't have been found in that trailer, or semen on the sheets or the bedding. Not a chance that those things wouldn't have been found. And the fact that there is zero physical evidence to corroborate a very, very weak and ridiculous confession taken by that young man should be enough for the Wisconsin prosecutors and the Wisconsin police to walk away from that case.
Yep.
All right, Dr. Kennebaugh, I'd like for you to talk a little bit about how forensic psychologists could have assisted in Brendan Dassey's case.
Okay. I think that one of the things the judge saw when he ruled at the motion to suppress hearing was that he saw nothing in the videotape that worried him. And I think that we could see it if you're schooled on it, as we've been schooled on it tonight, but the problem is what's psychologically coercive to one person may not be psychologically coercive to another. It's individually based. So that's why it's important to have a forensic psychologist talk to Brendan and ask him things like, I see in the videotape you're silent here. What are you thinking? Or when the police said, we can help you, what did you think they mean? Because it's important to know from his perspective, and that's what a good forensic psychological evaluation should do, which is ask him questions so that the court can understand what was going on for him in the moment. Additionally, a forensic psychologist will talk to other people who know Brendan well, who are not just his mother. He goes to school. That right there is a wealth of information. The psychologist will talk to his teachers saying things like, when he doesn't understand, does he tell you he doesn't understand? When he doesn't understand, how does he act? Does he get quiet or does he get assertive? A forensic psychologist would also, I have problems with imagining how he understood his rights as well. So a forensic psychologist will could ask the teacher, could he understand the words that the police used in giving him his rights? Those sorts of things.
He's a minor. They had him, before they brought him into that room, he waived his Miranda rights. And he's a minor. He doesn't know, I'm sure, like a lot of people, adults don't know what that means, waiving your Miranda rights. Anything you say will be used against you. If you have to waive your Miranda, don't. Just don't.
Also to test him for listening comprehension so that we can see what his listening, at what grade his listening comprehension skills are at and whether or not we can expect this. These are things that move you beyond what you can just see in the videotape, and I think that the judge saw Brendan has the power to make rational choices. That's what the judge said, and I think a forensic psychologist would help you understand that's not the case.
All right, Dean Drizzen, what are some of the police interrogation reforms that you would recommend, and how would you go about getting the law enforcement community to endorse those proposals?
Well, one of the things about this case that is important to remember is that this was the first interrogation in a major homicide case in the state of Wisconsin that was electronically recorded from start to finish. The Center on Wrongful Convictions of Youth was involved in the litigation that led the Wisconsin Supreme Court to electronically record all interrogations of juveniles. And if that had not been recorded, we wouldn't be here today. There would be no movie, or at least there would be no story of Brendan Dassey's case, and we would be left arguing about whether the police officers in this case coerced Brendan or whether And the only information we would have would be the police officer's side of the story and the story of a intellectually challenged 16-year-old kid like Brendan. We just wouldn't have a movie. So first off, every conversation, interrogation, interview between a child and a police officer needs to be electronically recorded. Same goes with adults who are suspects as well. With regard to interrogation tactics, I think we outlined all that was wrong with this. I mean, they violated their own protocols. They know not to feed facts, but they fed facts. They know not to make promises of help, but they made promises of help. They know, or should know, that police officers are not human lie detectors, and they have to stop training police officers to think that they are.
Mm-hmm.
So is there a technique that you would recommend other than the Reed technique?
There are a couple of techniques that are out there that I think are much better than the Reed technique. There's a technique that is picking up steam throughout Canada and throughout the UK. It's called the PEACE technique. It's an acronym, and I'm not going to try to remember what all the letters stand for. But it's a technique about investigative interviewing. It's not a confrontational interrogation. There's no lying or false evidence ploys allowed. But you keep the suspect in the room and you get him to tell his story in a narrative fashion. And then while he's in the box, you go out and you send police officers to break his alibi and to come back at him and show that you know that he's lying. And over the course of time, many, many suspects will confess when they know that they're caught in a lie. And the interrogation and the confession rates of suspects in the UK with this less confrontational approach are just as high as they were before they made the switch from the techniques that we see in the United States.
Thank you. That was beautifully said. I mean, why are we doing this? Why do we constantly abuse each other in this world? Like, let's pick each other up, be nice to one another. Like, say something nice to somebody today. Go out of your way and do something nice. Because, you know what? The world needs more nice. The world has enough hate and enough anger and violence. Let's just be nice.
All right, I'm going to move along a little bit, and I want to get back into the series. And perhaps, Mr. Mylan, I think this might be a good place for us to have a conversation a little bit deeper about it. How can the public better understand the theater of the courtroom versus the theater of programming that you see in Making Murder?
Fair of the courtroom versus the fair of the program?
That's right.
All right, I'll try to run with that. I don't know if I'm going to answer this exactly, but I'll just a little bit, but that's all right. I look at this, like the dean, I did a crash course on Making a Murder this week. I watched all 10 episodes in 3 separate days, and I found myself screaming at the television and screaming at Mr. Kratz, like the rest of you. And as I broke this thing down, this is how I look at it. It started out with the conflict of interest. I mean, how did this whole thing start going south? That they were wise enough to call in a special prosecutor, a moronic special prosecutor, but they brought in a special prosecutor, but they weren't wise enough to keep the original cops out of this. And that's shocking. So that's how this whole thing starts going sideways. Followed by Kratz's press conference regarding Mr. Dassey's confession, which was outrageous. Followed by the fact that Kratz commits a huge discovery violation by questioning Bobby Dassey during the trial about a statement that the defense attorney's never heard about before, followed by the defense attorney for Brendan Kaczynski absolutely selling him out with the investigator, followed by a series of rulings by the judge that were outrageous. One, no gag order.
Whoops.
I mean, why prosecutors and defense attorneys are stepping up to cameras after every day of trial is beyond me. And then followed by what I already mentioned, which was zero corroboration to substantiate confession. This was more than a perfect storm. This was an absolute disaster.
Exactly.
I know I didn't answer your question, but I just had to say those things.
This guy's great. He's great. I was worried about him because he's a former DA, but I like him. He's informed.
All right, then, how concerned... I'm not going to let you off the hook. How concerned should the public be, then, about police planting evidence and that sort of thing? Is that something from your experience as a prosecutor? I think you said, you shared with me that you were prosecuted for 25 years?
Yeah, I was prosecuted for 24 years, most as a Cook County prosecutor. In the very end of my career, I was a federal prosecutor. But, you know, the reality is most police officers, and I think everybody would agree with this, most police officers and most prosecutors want to do the right thing. The problem is we've just seen too many false confessions and wrongful convictions. And I got to tell you, for me to say that, that's a tough thing to say. I mean, it was a tough thing to see the light. It came upon me maybe 16 years ago. But it's just true. One wrongful conviction is one too many. And in Cook County alone, we've seen dozens. And throughout the country, it goes. This isn't just an Illinois problem; it's across the country. And so, to answer your question, it is a concern. Planting false evidence, does it happen? Yes. Do I think it probably happened in this Dassey case? Yes. Based on the key is inexplicable to me how they missed it 7 times and found it on the 8th time. The bar I'm not so sure about. But to answer your question, planting evidence I don't think is a huge problem. It's always a concern. But taking false confessions, which end up in wrongful convictions, or misidentifications, which end up in wrongful convictions, is a huge problem in this country, and it is something for every one of us to be worried about.
So one of the things I think that is interesting in the song that we heard, that kind of picked up on the theme, is this of fairness to individuals who are in lower socioeconomic statuses. How much of that plays a part or a role in our criminal justice system?
It's huge.
I'll start with Dean Driscoll.
Well, what you saw in Making a Murderer is you saw the 2 best lawyers that Steven Avery's money could buy. I don't think the fact that they were paid a substantial amount of money would have made a difference. Both Dean Strang and Jerry Buting are just criminal defense attorneys who, at heart, and they would have litigated the heck out of this case. But it did enable them to get experts and hire the best experts to work on the case and present a much stronger defense on Steven's behalf than what Len Kaczynski did for Brendan. Len Kaczynski was paid $40 an hour to represent Brendan Dassey, and that's shameful. That's not enough to keep the lights on in most criminal defense attorneys' practice. They have to lose money to take a case like this, and the quality of defense attorneys that you often get at $40 an hour is pretty atrocious. Brendan would have been much better off if he had the Wisconsin State Public Defender's Office representing him instead of one of these contract attorneys. So I think that, poor people lose all the time is really a very apt way of describing what happened to Brendan Dassey.
Let's talk about the press conference. What are the thoughts on having the press conference with so much information coming out prior to there being a trial?
Can I take this one?
You can take this one. I see you're eager to answer that one.
Yeah, it was outrageous. I don't think the Wisconsin state rules are much different than Illinois. And in Illinois, you can't do that. You can't hold a press conference like Kratz did and lay out all those details, which, as we now know, really weren't laid out in Dassey's statement. They were really laid out in the police statements. You just can't do that. And what really bothered me about it is that no judge stepped in. The trial judge didn't step in and say, what was that all about? And admonish him and then issue a gag rule. Instead, it was the opposite. Both sides came out after that and held press conferences every night after trial. And that didn't help Mr. Dassey or Avery. So, as I stated earlier, everybody messed up in this case, from the defense attorneys to the prosecutors to the police to the judges. Nobody stepped up and did the right thing.
I mean, there on that point, the story that was told during the press conference, which was lifted from Brendan's confession, which was fed to him by the cops. I think there's something really tragic about that story that's gone, frankly, overlooked in all the Making a Murderer craze, which is that this is a story which all of us, I think, up here believe couldn't possibly be true. This story of torture, of stabbing and throat cutting and hair cutting and choking and so on, sexual assault. But it's a story that's been presented not only to the people of Wisconsin, but to the Halbach family as a true account of their loved ones' final hours. And I think that's a tragedy, that they're laboring under this belief that's been given to them by the prosecutors in this case, that that's what happened to her. I'm not minimizing what did happen. To be murdered is a horrible thing. To be shot in the head is a horrible thing. But this narrative of torture that the state has accepted, it's almost a crime against the Halbach family to leave them under that belief.
If we're just stepping in and taking it over from you.
Well, actually, I actually had a question for
okay,
you.
but I want to just talk about two things. So the question about how the theater of TV differs from the theater of the real world. is the one point, and then I want to talk about making electronic recordings law in Wisconsin. So people, I think what this Netflix series did is it helped people understand what can go on in an interrogation. People didn't have any idea that this is what happens. I interview people who've been wrongfully convicted all the time. I'm retained on cases where it's a disputed confession all the time. One of the things that, in adults, this happens to adults, it's not just a kid thing. One of the things that makes it so easy is that people think this isn't how the police follow rules. Police should do it in a lawful way. And so I think the thing that I like about Making of a Murderer is that it helps people understand how things can happen. That's my one point. My other point was, picking up on what Steve said, people, I think, mistakenly people fail to appreciate what kind of resources they can get when they have a public defender's office. The person that made it so that all interrogations have to be videotaped, the person who actually took the case to the state appellate court was Eileen Hirsch, who was a public defender. I was a forensic psychologist on that case. I testified. One of the things that was so great was Eileen had behind her and with her not only the clinic here and the resources of the clinic here, which Steve was great at, but also the resources of her office. People think if I hire a private attorney, then I'm getting something good. Well, in fact, you might be, but you're going to have to pay a la carte for everything you get. Like if you want an investigator, you have to pay for that investigator. If you want a psychologist, you have to pay for it. When you have a public defender in the public defender's office, it's not that way for the defendant. And I think that that's something that TV does a poor job at not accurately portraying what great resources you can get when you're represented by a public defender, often. So thank you for allowing me to sort of take over there.
Well, you have the floor right now, and I had a question for you, so that actually ties in really well. So can you talk a little bit about this idea that law enforcement went to Brandon Dassey's classroom? They pull him out of the classroom and they bring him into the principal's office. Can you talk a little bit about what some of the effects of that would be on him?
How are they allowed to do that? I mean, come on. How are they allowed to do that? It doesn't seem right, especially without an adult, without legal representation. They just pick you up out of school. They don't even tell your parents that you're leaving school. They just come and get you. Like, what? How is that? You can't do that. That's like kidnapping, taking my kid from somewhere that I didn't tell you that he could go. This case, I mean, everything about these cases infuriates me, but whatever.
Okay, so of course I'm not a lawyer, but for all you people who are getting credits, it should make you think of JDB versus North Carolina. Because the idea is, what happens when you go to the principal's office? Like, let's think about those times that we went to the principal's office. You can't just get up in the middle and say, I'm out of here. You have to stay there, okay? So and we think you don't go to the principal's office for something good. You go because you're in trouble. And I think that shapes the whole interaction with the police. And it also shaped this idea that was repeated up until the fourth interaction with the police, which is, I talk and I get to go. Right? He went home the first time, he went home the second time, he went home the third time, and sure enough, at the end of the fourth time, he's like, well, do I get to go home now? And that's not just unique to a person with a low IQ. I've interviewed many people where they've said, although I told them what they wanted me to tell them, that I killed this person, I thought I'd have dinner with my parents that night. Or I thought I'd be able to take my daughter to a soccer game that evening. So it's the repeated interaction that starts with the school that I think sets the precedent for him of what to expect. It also impairs his ability to appreciate the adversarial nature of what's going on and how it's increasing. So I think its impact is great, and it's one that's cascading over his interactions with the police.
So one of the
brilliant.
trends that's happening across the country now are these conviction integrity units that you're finding in prosecutor offices. So independent units that are dedicated to reviewing allegations of cases of wrongful convictions. Does this suggest that prosecutors have a proactive role in addressing wrongful convictions? All right, Mr. Mount.
Prosecutors let me just back up. When it comes to taking somebody's freedom, and this is what every prosecutor should think about, when you take somebody's freedom, it's not like horseshoes. It's close doesn't cut it. You better get it right. And when a prosecutor's office locks somebody up, they better use the same sense of urgency to fix it if they've locked up the wrong person. And that's why these conviction integrity units or DNA review units, whatever you want to call them, are so important. Every major prosecutor's office in this country should have that unit that goes back and looks at these cases. We started it in Cook County back in the early 2000s. We copied it off of San Diego. San Diego actually had that unit, and then we opened it up, and we were very successful. We actually exonerated a number of people over those years. But there's another important component of this, and Wisconsin should really start to get it, and that is when you're a prosecutor and a potential wrongful conviction is brought to you, the adversarial system should end. I mean, one of the biggest problems about this is you go into court and you're battling, and it's all adversarial. But when you are brought a potential wrongful conviction, that has to end, and the prosecutor should work with the defense attorneys to find the truth. Forget about win or lose, let's just get it right. And that's not what you're seeing in this case. The fact that Steve and Laura and Tom have brought this to the appellate court and, to post-convictions, the appellate court, with zero success in light of what we just watched. And now they're in the federal court, and I bet Tom today is going to win the Dassey case, and I hope I win that bet, and I'm convinced I'm going to win that bet. But Brendan Dassey will walk. He'll get out because he has really good lawyers and because the truth is going to come out. This is just too embarrassing. But I hope that Wisconsin wakes up and they get, in regards to wrongful convictions, the adversarial stuff ends and they work shoulder to shoulder with the defense bar.
All right, we're about time for one more question, and what I'd like to do is I'd like to find out from each of
This
you
was so good. I really enjoyed this. I'm like, no, I don't want it to end.
your thoughts are on this. We've received multiple questions from the audience that are simply asking, why wasn't Brendan Dassey's mother in the interview room? Dean, Theresa, I want to start with you. We'll just go right down the line and get some thoughts on that before we close out.
So in the state of Wisconsin, there's no requirement that a parent be present when their child is being interrogated. That is a requirement in about 12 or 13 states around the country. In Wisconsin, it is considered a factor that a court may consider in evaluating whether the resulting confession is voluntary or involuntary. But the fact of the matter is that Barb Dassey, who is somewhat of a pit bull in terms of the way she defends her son now, was not given information that she needed to have in order to be able to help him back when they were interrogating him. Police aren't required to inform parents what the purpose is of the interrogation, and in this case, these investigators downplayed or minimized what they were doing. They said, we just want to ask Brendan a few questions, he'll be back in no time at all, call us a little bit later and you can come pick him up. And so she gave permission to them to interrogate them, and she's had to live with that decision for the past 8 or 9 years. So one thing I want to say is that she should have been there, but even if she were there, I'm not confident that she would have been able to adequately protect Brendan.
Yeah.
Police officers are trained to marginalize parents. Reed trains them to do that, to sit them in a different part of the interrogation room, to talk to them beforehand and say, please don't interrupt us. So parents are powerless during interrogations when they're present, and too often they do more harm than good. The reality is what we need in interrogation rooms are lawyers. Lawyers need to be there for children, not parents.
Yeah.
The only thing I would have to add to that is that one incredibly positive thing to come out of Making a Murderer and the story of Brendan and the story of Barb, his mom, is that there are states around the country that are starting to consider making important changes in exactly this issue, whether or not a parent or a lawyer needs to be present as a requirement in the interrogation room when it's a kid like Brendan who's being interrogated. Tennessee is considering adopting a law to this effect. Rhode Island, a bill has been introduced requiring either a parent or ideally an attorney to be present for children like Brendan in the interrogation room. California also considering a bill to that effect. Let's not stop there. Let's get this moving in Illinois. Let's get this moving in Wisconsin. Let's get this moving
everywhere.
Because we cannot have another Brendan Dassey.
Everywhere, yes.
I think that, and I've said this for years, I don't think it should be an or, parent or an attorney. I think it should be an attorney. And here's what I think is a good indication of, you could call her a pit bull. She's probably that when she's on firm ground and understands the playing field, right? When she does.
And when she's not in a room with cops that are trying to interrogate her son. And probably make her feel minimal too. Make her feel like she's, her role should be minimal in that room.
Doesn't understand what goes on. What did we see? We saw her ask the police, did you pressure him? That question is so wonderfully naive that it lets you know that she doesn't understand the adversarial nature, that she doesn't understand what's going on. She loves the boy, that is clear. So it's not about love, right? But it's about whether or not you truly understand. And I think so frequently I've seen parents whose understanding of the legal system and of their Miranda rights are sometimes, unfortunately, at the level of their child because they haven't gone through it themselves. Remember, you see later on in the movie where they're talking about what does the word inconsistent mean. He asks the mother's like, I don't know, what do you think? They sort of have this little back and forth, right? So I'm not sure that she would have been able to properly advise him. And I think that if we see her as a pit bull, we don't realize then that this may not be an arena in which she can actually show those skills. So I think the way to address this is to have an attorney present. I've also seen cases where parents were present. They told the kid something like, you need to talk to the police. I want to go home after this. I'm sick of being here. And the judge said, we saw there was a parent present. It's fine. So parents being present is certainly not enough. And if we stop there, this kind of thing will continue.
And parents don't know the law. I mean, yes, of course he should have had a parent there, but in reality, she's absolutely 100% right. The person who could protect Brendan is the lawyer in this situation, and that's really who he should have had in the room with him. But again, like they said, they didn't know it was adversarial. They didn't even know that they should have had a lawyer because the cops downplayed the seriousness of the purpose of these interviews with Brendan.
Continue to happen.
I differ slightly with Steve and Dr. Kavanaugh in that I believe that if had the mother been in that room, they would not have obtained admissions against his.
It would have been a whole lot more difficult, and he wouldn't have just cowered to these officers if he had a parent, I think, with him. Because he wouldn't want to lie and get himself in trouble with his parent, you know? I mean, I don't know. I think, like, in the long term, in the long run, when you're 16 years old, your parent, you'd be more scared of your parent than an officer, most likely. So you wouldn't want your mom mad at you. You wouldn't want to be telling your mom stuff that wasn't true or whatever.
Those long delays, and when the kid is saying, I didn't do it, and they're saying, they're going, the head, Brendan, the head, come on, what happened to the head? I believe she would have stopped it. And I believe the reason why she wasn't in the room is because they didn't let her in the room. That's what I believe. I believe that they knew that, the police knew that their odds of obtaining admissions from that young man plummeted if she wasn't in the room. And so she wasn't told and wasn't invited to the room. That's what I believe. And then just one last point on the confessions taken by those police officers. Think about it. The cops knew they were on tape and they were behaving that way. I mean, how moronic is that? I mean, they know the whole world is going to be looking at this someday, and they behave that way on tape. Now, to me, that's one of the most shocking things of the whole case.
Well, I want to thank the panelists tonight for their conversation, their input, and their insight. And I do believe the world is watching the tape.
Okay. It takes a village to put a program like this on, and it takes a leader to allow the villagers.
Okay, they're just going to do their thanks and who everybody is. So I'm going to mute him, and I'll just let it keep playing until the end in case they do, like, people on the screen or whatever. Yeah, so I thought that was really interesting, the conversations and what can be done to improve or change the way that false confessions are being handled, and how do we move forward from here. And I loved the perspective of the former DA. I was really surprised that he's become enlightened and realized that these investigative techniques are terrible. And I wonder what that peace technique is that Steve Dresden is that how you say his name? I don't know. That he was talking about. That would be interesting to learn more about. He said it was in England or something like that. So I don't know. We obviously should adopt something else, because we have way too many false confessions and wrongful convictions in this country. So hopefully the laws can change and things can be done. But it takes forever to get things up to date. And by the time it gets up to date, it'll be, old news, but whatever. So hopefully things will change. But we need more people like Brendan to be released and shown as an example of, hey, this is what not to do. And going forward, we need accountability for these officers, for these people who lie. I still don't believe how it's still acceptable that officers can lie to you. I mean, I've known this forever, but it still just, it baffles me that they can lie and say, well, we have all this evidence against you. No, you don't. I wasn't there. I didn't do it. And not a lot of people are going to hold strong and hold to their first story when they're constantly told that they're lying. They're constantly, if you ever want to go do this class, I guess there's a class. I don't know. That was really interesting, and I enjoyed that immensely, watching that presentation and the discussion as well. So hopefully you guys enjoyed that. I thought it would be a good little palate cleanser after watching all those horrible traumatic investigations or interrogations, I should say, with Brendan Dassey. So thank you for sticking with me. Up next, and I think the next episode, we're going to start looking at the trial. So first, Steven Avery's trial, and then we'll come back to Dassey's, because we're just going in order. All right, so I will see you in the next one. Thank you so much for watching. Please hit that like button on your way out, and I will see you in the next one. Take care. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.